Section 62. The bill seeks to remove the upper age limit for qualification as president for reasons including the need to allow the President of the Republic to appoint qualified, experienced, and competent Gambians to appropriate positions in government, including the need to provide for every Gambian without discrimination on the basis of age to present themselves as candidates for the office of president. Now, Section 62, or the proposed amendment to Section 62 is incidental, it's only incidental to the proposed amendment to Section 141, which is the primary reason for the introduction of this bill. And the objects and reasons for the introduction of the proposed amendment to Section 141 is to give effect to the desire of His President, to the desire of His Excellency the President, to appoint as many Gambians to the judiciary as possible, particularly in the superior courts of the country. If this bill is passed, it will pave the way for the first time in the history of the Republic for the appointment of exclusively Gambian judges to the highest court in the land, the Supreme Court. It will be the first time in our history as a nation that we would have had a Supreme Court that would be fully empaneled by Gambian judges. The age limit of 70 years at this moment, we believe, unfairly excludes a group of very experienced and senior members of the Gambia Bar who are willing and ready to serve on the bench. We have carefully looked around international best practices from Commonwealth jurisdictions and concluded that the age of 75 is a reasonable upper age limit based on our study of practices in common law jurisdictions around the world. In light of this fact, we look at the entire Constitution to see which other provisions may also hamper the ability of Gambians to take up public office. And we came to the conclusion, and to the best of our belief and knowledge, that Section 62, which imposes an upper age limit for qualification as president, is the only other provision that we deem discriminates on the basis of age. And it was decided that it may appear discriminatory if we seek to amend Section 141 to allow for the appointment of Gambian judges to our superior courts, and not amend Section 62 to allow for Gambians of all walks of life and age to submit themselves for election as president. It is in view of these reasons that these two proposals to amend the 1997 Constitution have been put to this August Assembly for consideration and passing. I will perhaps at this point allow the honorable members to engage in the debate, make their statements, and I'll be more than happy to respond to any questions that they have on this motion. I thank you.
Before we move on to the debate, any seconder the motion? Honorable member for Minority Leader, please.
Thank you, Honorable Speaker, for giving me the floor. Let me thank the Minister of Justice. This bill was actually hastily passed here previously in this Parliament. Then he was outside. But when he came in, being the legal advisor to the President, he allowed the President not to sign that bill, the bill that was passed through this Assembly before. So, Honorable Speaker, I rise to second the bill entitled to amend the Constitution of the Gambia under Section 226 and for connected matters. Honorable Speaker, the bill really is not controversial, and then I believe this will be the fastest bill that will pass through this Assembly for a simple reason. Section 62, which we seek to amend, is to remove, deleting the word put more than 65 years. Honorable Speaker, the Assembly here today, we were part of the then opposition who were forcing the government, the then government, to amend this constitution, this provisional constitution on our GOFA reform. I stand to be corrected. Then I think if such a bill then is tabled here, I don't think there will be any controversy. According the minister said also, it is definitely discriminating. If we look at Section 33 of our Constitution, which is against our Constitution. So for Section 62, I don't think we need to debate on Section 62. Because when we are in opposition, we are forcing the then government to amend this clause of the provision. Now today we are in power. I think it will have an easy right in the House. And then the same section warranted some Gambians to go out in April. What was the date? Can somebody help me? April 14 and 16, until one veteran opposition by the name of Sandel died on electoral reform. And in those electoral reforms, this Section 62 was captured in those demands. Then I believe if such a bill could come to me if unless we want to happen otherwise, but it could just have an easy right. And then on the other section, that say it helped our judges from 70 to 75 years. You see, Honorable Speaker, wisdom is not acquired at the university. Wisdom is acquired from the old age. I will use an example today. We have two veterans in this house. That is Honorable Member for Wuli and Serekunda. Today, when it comes to age, they are the oldest in this house. But how can we tap from their wisdom if they were not in our...
Madam Speaker, point of observation or clarification. The Honorable Member for Serekunda and Wuli are not the oldest in this National Assembly. You have members here who are 73 and 68 and 75.
Okay.
Thank you, ma.
Yes, I was...
But sorry, off the record, Honorable Member, maybe they were not National Assembly members. Yes. Specifically, Honorable Member for Upper or Lower New.
Lower New. No, in general, okay, let me see the seniors, maybe who are at their 60s and their 50s. Today, if we want to tap from their wisdom, the only way we can do it is to associate with them. And we have seen it. So, what all the bill is seeking is some of the young also, we engage with the older so that we can tap with their from their wisdom. Then looking at the bill, I don't think the bill actually is not controversial. As I said earlier, it could be the fastest bill to pass through this assembly. So, Honorable Speaker, on that note, I rest my case to listen to other members.
Thank you, Honorable. It has been moved and seconded that the bill entitled to amend the Constitution of the Republic of the Gambia under Section 2262 has been moved and seconded. Those in favor, please say aye. Those not in favor, no. Now it's open to the floor for any member to take part in the debate. He had a privilege after seconding it to make his contribution, and that is why he may have a second bite of the share. Anybody who wishes. Yes, Honorable Member for Serekunda, Wuli.
Thank you very much, Honorable Speaker. Section 226, subsection 2 of the Constitution commands that this National Assembly must not pass any bill to amend the provision of the Constitution which are not entrenched unless the bill is published in at least 2 issues of the Gazette. And the second publication must be within a period of 3 months. And after the second publication, the bill must not be brought before us unless at least 10 days elapse. I must say that we are provided with 2 issues of the Gazette. One that is published on the 13th of April 2017, which constitutes the first publication aiming to delete the additional provision in section 62, subsection 1b, which bars anybody above 65 from being qualified to be a president of the Republic. In the same vein, the first publication deals with section 141 of the Constitution, which required judges to vacate their seats at the age of 70 and seeks to increase the age to 75. The second publication is dated on the 13th of July, 2017. This is 3 months in between. So essentially, this bill is brought before us today on the 25th, and clearly it is more than the 10 days interval required. So we must say that this bill is constitution compliant, and we congratulate the Attorney General for adhering to the provision of the Constitution. The Constitution under Section 101, subsection 2, asserts that no bill other than a bill referred to in subsection 5 shall be introduced into the National Assembly unless it is accompanied by an explanatory memorandum setting out in detail the policy and principles of the bill, the defects which is intended to remedy, and the necessity for its introduction. According to the object, we are told that the objective of the bill is to facilitate and encourage qualified, competent, and experienced Gambians to be appointed as judges of the Supreme Court and to also be contest elections as president. It is important to emphasize that from my own perspective, the real object is to put an end to what is ostracism in constitution building. Section 26 of the Constitution is very clear. It asserts that every citizen of the Gambia of capacity shall have the right, without unreasonable restrictions, to take part in the conduct of public affairs, either directly or through freely chosen representatives. It affirms further that the Gambian has the right to vote or stand for elections at genuine periodic elections for public office, which election shall be by universal. In essence, what is brought before us is to remedy what in fact was a contradiction within the Constitution itself, giving rights in one instance and taking back that right in another instance. So a consistency is being asserted by bringing this bill before us. My only dilemma, Honorable Speaker, is the person who is really bringing the bill before us, because I've seen in what we are given the name of the President of the Republic, H.E. Adulba. What we are used to is the person who actually brings the bill will have the name of that minister in what is called before us. What I know for fact is that if the President is to appear before us under Section 77 of the Constitution, it is the Vice President who can represent the President. Section 73, subsection 3 says, the Vice President shall answer in the National Assembly for matters affecting the President, and the President shall be entitled to send a message to the National Assembly to be read on his or her behalf by the Vice President. Attorney General will be able to explain why in this instance we are having the Attorney General actually bringing a bill with the President's name there. And I would say that the Constitution requires for the office of Vice President to be filled. And this is the reason, so that the principal assistant of the President will appear on behalf of the President before this August budget. And if that view is still correct, then I would believe that somehow at the end we should put the Attorney General and Minister of Justice when we come to look at the bill in the Committee of Supply, so that history will not find us wanting in our deliberation. Thank you very much.
Thank you very much, Madam. The amendment of Section 62 is wrongful. It could have taken place 15 years ago if this assembly was really an assembly. But it was an assembly there. They wanted it changed, but they did not have enough to bring about change. So they succumbed to something which was bad. Assembly and the country. Like, it is already pointed out by the member of Serekunda West, Serekunda West, Serekunda. The same law gives me right to be elected to any office. And the same law says, no, but you cannot be elected to this particular office. You know, that is there are many contradictions in the Constitution, not only one. Because in our Constitution it is stipulated very clearly that everybody of age has a right to be elected or to elect. But the same law says, no, but you cannot be elected unless you speak a foreign language. That is, to become a member of Parliament, you have to be able to speak English. So the vast majority of who don't speak English at all have been denied that fundamental right. It's always stipulated in the Constitution. That is also the fundamental outline Constitution in the Constitution. And in Section 105, it is stipulated that we can use, by an act of Parliament, we can use any of our languages. See, that also has to be done. If you want to be speaking honestly about democracy and equality, then that section also has to be taken into consideration, because you cannot say some citizens have a right to be elected because they speak a foreign language, and the vast majority don't have the right to be elected because they don't speak that foreign language. For me, that is the most serious contradiction in our Constitution. And I think we should think about this seriously. When we say independence, it does not necessarily mean having a flag, having a national anthem. It is to be yourself. The freedom to be who I am in my country. That is what independence is about. And the right to assume the responsibility of being myself. The right to decide what I want and what to do and how to do it. That is what we mean by freedom. But the vast majority of people in this country have been would have been better here than I am. But because they don't speak English, and I speak English, they don't come. So it is good that this thing is now taking place, because at least this parliament, by all indications, we are now beginning to be ourselves. Because we can now assume what we think is the best interest of our people. So to change this amendment for me is fundamental and it's local. And as for the other amendment, like somebody said, has already pointed out, I think the older I have a battle, the older a person gets, the more diplomatic he will see. That is true, but not in all cases. There are some old people who are not diplomatic at all. These are nothing but that's the truth. It means there is something else in human being which makes him or her diplomatic. And if you lack that, however old you may be, you will always be not diplomatic. So the change also here, the amendment is good, because like the other day I was talking to somebody, and this is a matter to consider by the National Assembly. I went to the Social Security with somebody who was claiming his dues. But when you went there, you have already been given the first test, 55%. But you have to be 55 then before the amendment of the law to get the second payment. Now the amendment says it was 60. He didn't know that. Can I say what? You went there, you have to go to 60 yet, so you cannot get. You know what the man told me? And those in the office there, they say we are having huge number of complaints here about this amendment. That they are saying that most people die before they are 60. So they cannot access their tools, and they die and leave it behind. So this is another thought we have to think about whether or not we should amend this law to come back to 55. You know, they're not really like people the money they think they are saving, they are for themselves and not for their children. Yes, this amendment also is good, because some people, and I think it generally affects human beings, when you are big and you are doing nothing, you get old, you age very rapidly. There is no question about that. You age rapidly when you do nothing. But when you are engaged, you are occupied. That there is something that serves you, that makes you think that you are still young. Psychologically, you move on. So to have this at 75, we have presidents at 90 something. Mugabe is now 90 how many? 94. And I know one Indian president, he was 80. And I know one president in the old Soviet Union, he was 80 something. So why can't he brought this 75 and still be intellectually right? So, Madam Speaker, I think these are very necessary amendments. But, Madam Speaker, there is another necessary amendment which is fettered. It's fettered, and that's what fettered this amendment. They are supposed to mention. Section 91D fettered people to bring this because they would have been sent out their parties, and once they were sent out of their party, they lost their seats and they lost their survival means. So everybody was afraid of this.
Thank you very much, Honorable. Maybe you should have brought that to the attention of the Honorable Attorney General earlier, or you bring a private member's bill. I'm sure it would have been. The Honorable Member for Banjul South.
Thank you very much, Honorable Speaker. Honorable Attorney General, we thank you, we applaud you once again. I think this is the second time I'm applauding you today for bringing in this amendment, which I think was unnecessarily added into our Constitution. My honorable colleagues have already mentioned laws regarding this under our Constitution, but I am going to quote the Universal Declaration of Human Rights, Article 21, of which also makes this illegal. It states that everyone has a right to take part in the government of his country directly or through freely being chosen as representative. So based on that law, it should have been deemed illegal in the first place. It also states in subsection 2, Article 12, Section 2, that everyone has a right to equal access to public services in this country. So restricting the age should also have been deemed illegal. So I think I should applaud you by bringing in this bill. Article 2 also entitles everyone to the rights and freedoms set forth in this declaration without distinction of any kind such as race, color, and I think that should also include age. So I will applaud you, Honorable Minister, and urge my honorable fellow members to not take long in this debate and ratify this amendment. Thank you very much.
Thank you. Honorable Member for Basse.
Thank you very much, Honorable Speaker. Honorable Attorney General and the Minister for Justice, you and your team of expertise, we thank you. Honorable, if it is correct, we say we talk less. If VC was talking more, meaning that it's not correct. And if it is not correct, we have to protect our identity and our dignity. Because after passing the bill, whatever happened after, they will not say the Minister of Justice. They will not say the judges. They will say who is the National Assembly members. That's why if you can remember, when they came newly, if any one of them is speaking, they say this will not be a rubber stamp parliament. Why? We are just saying that. So whom are they referring to the rubber stamp parliament? It's those who can be for them. Because the environment was not conducive. It's the environment that was not conducive for you to express your view. Even if you said it, it will be embedded here. It will not go further. So therefore, I think the era that we are in now is the era of awareness. If that is the case, honorable members, let me tell you one thing and try to believe on it. That cabinet cannot do anything in this country if they don't come to the parliament. You know what the cabinet is telling us? They know their problems and they are finding solutions to their problems. And to them alone, they cannot find a solution to this problem, but they have to come to us. And we know that we have problems. But they don't come with the solution to our problem. But their problem needs to be solved now for them to be at ease. And while we have problems, and the Attorney General knows that we have problems. This is a food for thought. If they know their problem and they cannot solve it without us, then let us try to know our problems and find solutions for them. He has mentioned Section 91D1. That's the only reason why we are calling us then Robert Stamp Parliament. Is because of Section 91D only. And still it is in the Constitution. The only free man today in this parliament is me. I'm the only free parliamentarian in this parliament. I'm not under any political party. Section 91D1 will not be applied to me. Only me alone. But it will apply to all of you. So therefore, I think we use this opportunity not only to thank the Attorney General, but also to make an appeal so that his next appearing in this parliament will be the finding of solution to section 91B1. Thank you, Honorable Speaker.
Thank you very much, Honorable. Honorable Member for Central Badibu.
Thank you, Madam Speaker, for giving me the opportunity once again. Thank you, our Honorable Minister, for bringing such a bill to our attention. I think it's the right step in the right direction, because for the past years we have seen today that all the various speakers spoke about as it was contradictory to the Constitution. Okay, some other parts of the Constitution, Section 26. Madam Speaker, Section 62 of the Constitution limited our democratic rights as citizens. Since it was age control, and we all agree that people who are old, some who are old, they still have reason to support all the different people of the nation. But it should be borne in mind that this part of the Constitution, we are amending it not to suit anyone but our own sides. Because all of us are praying or yearning to be all one day and to serve the nation. So it's not meant for Mr. White from Bate or Mr. Z from Congo or Baka. We are doing it for the entire nation. We are representing Gambia. We want to show the Gambians that democratization of this nation has begun. The other issue is we want to put an end to segregation and discrimination when political socialization comes in. Because once you put the age barrier, you are trying to discriminate others who can have great impact on the development of this nation politically. Now, Madam Speaker, if you come to the other point, we try to stamp out mediocrity. Because once we put age barrier, we are promoting what we call as mediocrity in political socialization. So, opportunity will be given to people. We might see them young, but do they have the talent? Do they have the wisdom to serve the nation? So, we are trying to get rid of mediocrity in the Gambia so that efficiency and performance will be relevant. Madam Speaker, the other point of the bill, the other part of the bill, it talks about the judges. I think it will promote the impartiality of our judicial system. And it will promote experience, it will promote quick delivery of justice. Because all those people who take the age of 70 above, they might undergone under a serious training or serious low delivery system. So the experience that they will gather will be fast enough to rescue this country. We are all living witness to it. At the point in time, the judiciary of this nation was in big question because we did not have our own people who believe they could dispense justice or they could deliver up to expectation. Or maybe along the line, they are not also doing justice on their own cause. But I believe we're giving people 75 years, then we can have experience, we can have people who are ready to serve the judicial system. And an event, they do not serve our purpose. We have our right as Gambians to make an outcome. Madam Speaker, this will also help us to learn from other countries as we are in the age of globalization. We have to learn from how other countries they do with their judicial matters. What type of judicial system do they have? What caliber of lawyers or judges do they have in their judicial system? I think I will concur with the various speakers or honorable members that this bill is the right step in the right direction, and I'm here to give my full support. Thank you.
Thank you, Madam Speaker. am pleased and highly honored to contribute to this amendment of these two very important sections. The Minister of the Attorney General and the Minister of Justice is late going. The Chief Justice said going. We have the prosecutor do that going. The Gambia has got the qualified personnels, and all these are being realized by outside countries, while we need to leave our own resources to be utilized by other countries, and we have the opportunity to do that. We have seen what mercenary judges have done to us. We have seen what mercenary judges rushed to incarcerate our own people. The Mali would say, if you know the person, you would have sympathy. Those who came for money, and they did it for money. They left us crying over our own people, because the very people who were at the top were only interested in what was going to serve their interests. And here we can see, why do you need a controversy in a constitution? My honorable members have highlighted it, the member for whom you rest. If you have a law that is giving you the light, and you go by the back side, to only have that law to give you another, to take away from you, it's a bad law. To say that the law is special is a bad law. We, as members of this National Assembly today, will stand with pride, will stand with dignity, that we have our own people reforming our own constitution. Although it's in piecemeal, we are very much concerned about that section 91B. We are very much concerned about that. Honorable Minister, please, if you would not have it as a member's bill, please consider next time we come in here, you bring us that bill so that we can lean over something to justify our stance more. I give you my support, I give you my blessing, and I also pray that we take this virtually and pass it. Thank you very much.
Thank you very much, Madam Speaker. As the minority leader earlier mentioned, this is a non-controversial bill in the sense that the then oppositions, I would call it, were actually advocating for constitutional reforms. And important in that particular demands by the opposition saying is this upper age limit. We don't only consider it to be discriminatory in terms of political participation, but against one's rights as higher stated by the previous members. I also try to look at the procedures that should be followed to justify the laying of this bill before the National Assembly, that on the 13th April, the first gathering came, and then the second gathering came on the 13th July, and today on the 25th, it is laid before the National Assembly. So the required period is actually in line that the procedure of laying the amendment before the National Assembly for today is constitutional. And here, what one has to look at is it genuine for us to amend this particular clause of the Constitution. The quoted sections 26D that actually deny one's right to stand and be voted for. But as a matter, if we are to talk about discrimination, Section 62B, in my opinion, is a replacement of the position of the Gambians in the draft Constitution 1997. Gambians were up for term limit instead of age limit. The revised draft Constitution was what introduced the age limit from minimum 36 to maximum 65 in place of the term limit. If we are to amend to bring in to exclude or to remove the upper age limit, yes, we are not discriminatory against the old age, but the minimum age 30 is still in place. If, but not more than is deleted, we are still leaving behind minimum age of 30 years. Here there is a sense of discrimination against the young people. At 18 they have the voting right, that means they are obliged to stand and vote for any public election. So we need to look into that if we are to stand to say that we are against discrimination. Discrimination in any form should not exist. Being young ones or old ones, discrimination should not exist. Madam Speaker, if we are going to amend this, which is long overdue, we are reminding the Honorable Minister to also look into the term limit, which is also fundamental. Instead of age limit now, it is now going, the term limit should come. Every government should stay here not more than 5 years, 2 terms. It will be very lovely if we can see that amendment also coming before this August Assembly. Thank you.
Thank you very much. Any more intervention? Yes, Honorable.
Thank you very much, Honorable Speaker, for availing me another opportunity to share what I have with the colleagues at the National Assembly. Let me begin by commending the efforts of the Honorable Attorney General and Minister of Justice. Actually, I'm not going to take long because one issue I wanted to highlight have already been highlighted by the Honorable Member for Brikama North. Looking at the composition of the Gambia, it is a country where the youth form the highest percentage of our population. It is therefore important that in whatever we do, we factor them, let them feel that we are representing their views and their interests as well. So if we talk about the upper age of 65, and then we neglect the lower age of 35 or 36, I'm not too sure. I think 30 rather. I think we are not doing justice to the young people of this country. And again, to further avoid any contradiction in the Constitution, as alluded to by the previous National Assembly members from the respective constituencies, which is talking of 65 as we speak, and then we are thinking of or proposing to move it to 75. For me, my view is to avoid any contradiction in the future, let it be left open. Like the Honorable Member for William West have quoted a president who is in his 90s, and then he quoted a president he knew who was in his 80s. If that is the case, for me, I am with the view that let it be left open, in as much as you have the energy and the strength to deliver, and then the people are still interested in voting you into power, you continue steering the affairs of the state. But it's very, very fundamental that the lower age is also taken into consideration. Like Honorable Member for Basse said, I don't think we will have to delay much on the debate, but let us always remember and have at the back of our minds, in whatever we do, how do we capture the interests of the young people who form the highest percentage of the country. Thank you.
Thank you, Honorable. Nominated Member Yakuba Gaite.
Thank you very much, ma'am, for giving me the floor. I cannot be seated here and we're talking about discrimination in regards to the young people, and I would add my voice to it because I think I am in this assembly to represent the young people. When it comes to the amendment of age, the only consideration here is the upper age limit. Like previous speakers have said, the youths form the highest, youths are the highest part of our population. If we are talking about age, and if you want to convince me about the discussion on discrimination, that the whole point that we are doing this, we are making this amendment, is to avoid discriminating against a certain group of people, then I think the age limit that you cannot be president until you are 38 and you can vote when you are 18, I think that should be taken out as well. We either leave it open or we have further discussions on the issue and come to an agreement. I'm not in any way against amendments of the Constitution, but we all know, and I've been saying this since I got to Parliament, that there is a problem with this Constitution. We are all aware of it, and I would have rather we had a holistic approach, a holistic review of the entire Constitution than piecemeal amendments, because these are the problems that will come into play. We are amending age, 65. What about the age 30? Once we need experts to sit around this whole document and come with a new constitution, taking into account all these considerations, to avoid us making an amendment and coming back to make other amendments and coming back. That is what I am against. I know it is discriminatory for the age to be 65. I totally agree it needs to be amended, but I can also as well say it is discriminatory for it to start from 30. Why not 29? Right now I am not 30. It means I cannot be president, but still I can sit in the National Assembly and make decisions for the entire nation because I have a voting right. What do we have to say about that? That's why there was need for us to have a holistic approach in regards to the Constitution. And going back to my colleagues in the National Assembly, I think before we sit here considering any amendment to the Constitution, I think you should not only ask for, kindly ask for, you should make a demand for Section 91D to be taken out, so we can freely, without any fear or favor, deliberate on things accurately and appropriately. I think we should make the demand before we consider any other amendment for that amendment to be made, because I think it is vital in regards to our deliberation and consideration. Thank you very much.
Thank you, Ma. I wasn't going to contribute to this motion because I thought it was
of the case, and the previous speaker said, it wasn't even necessary to debate on a lot. But some of the few points that have been raised recently, just prompt me to add my little contribution. That is the amendment in terms of the age limitation on the section 22. Sorry, section 62 of the. I think is, and this is just my opinion, it is only wise we leave the minimum age as it is. Simply because age, and most of the speakers who spoke here before are talking about wisdom, experience, not about youth and what's the other word? Aggressiveness or whatever it is to actually be in consideration here. The point I'm trying to make is this. The presidency is the highest office of the land. And to be qualified for such a position, I think you have to be of certain age and experience before you can hold such positions. So at 35, what do I know? How much do I have I'm exposed to be able to say that I know what it takes to run a country with all the complexities that there is. So the youths are very much considered. This National Assembly is a platform for the youth of where you can start your career. And I think, if at all not all is well and everything not been level, you can vie for presidency, in your as a career. But at 35, I think, is even to me an age which is at the bottom level of somebody to try to actually vie for presidency of the country. I was just taking an example from the French president. Is considered to be one of the youngest presidents in Europe, but he's still 39. But even in this case, some people are thinking that he's too radical, that he's too young, he's too inexperienced. So if at all, we have to actually consider all these things and actually trying to make it so accommodating. Then why the age limit in the first place? Then why not 18? That you can qualify into such, because then you are discriminating those between 18 and 30. If we are going to drop that age limit. So I think in every case we just have to be a little bit specifically, or we have to actually know what we are looking for. So for the president to be at the age of 35 or younger, I think is an opportunity to actually experience anything, just like we had done in the past administration. At 29, when our president came to office, it's been evident that he doesn't know too much. So I think the age of 35 is about right to start from, and the upper age could be waived in some other cases to 70 or 75, or as others claim, to be open. That I don't think there's much of a problem. But I just want to actually contribute because of my little observation I just made recently, and that we pass this bill or this under this motion without much delay, as mentioned by the most experienced speakers before me. Thank you very much.
Thank you so much, Madam, for giving me the opportunity again. I also equally thank the Attorney General for bringing this bill before this August gathering to actually pass the bill. I actually don't want to make any comments, but due to recent intervention, prompted me to at least set my comments on this here. Regarding the age limits of 65 to above or 75 is very much welcome. And then issue of discrimination, that is the youth not given a chance to represent public offices like other presidents. If you go by some authors like Plato, they even prefer as a philosopher thing to go up to 50 years. By then you are born with material comfort, temptation and all. But when President Jai was 29, I assume office and become the president, you've seen the temptation, women around, pets, the desire to accumulate more wealth. But at a certain age, you go beyond material comfort. Nobody can actually bribe you. I mean, you have that kind of self-esteem in you. Do you understand? But you don't expect someone to contest presidency age of 25, 20, 25, 30. Those ones are actually, you need to go through a rigorous training, acquire knowledge and wisdom. In some countries like Nigeria, it's 40 plus. Right now, they are even demonstrating the youth are saying that they should be represented in the government. That is, they have to do the everything. Well, we are deliberating on 30. I think this 30 issue is not actually discriminating. Rather, it is giving us that avenue for us to acquire the requisite knowledge we need in terms of governance. But if we should bring it down to 25 to 20, this issue of temptation is going to be very high. What has happened to Gambia? He was young, and he has this zeal, this desire to accumulate wealth, and this has actually put him astray. So basically, for you to be above medical comfort, you need to attain certain age, at least to be able to deliver the interests of the people that you govern. So thanks so much.
Thank you very much, Honorable Speaker, and thank you, the honorable members of this Assembly, for your very insightful comments and refreshing debate. Allow me to quickly address some of the issues that have been raised. I'm starting with the issue on the name on the bill. The issue raised by Honorable Member for Serekunda. The President of the Republic is the chief guardian of the Constitution, and that by convention, every constitutional amendment that is proposed by the executive is done in his name. And that is why his name appears on this bill. And this position is supported by the Constitution, the 1997 Constitution of the Republic of the Gambia. I start with section 76, subsection 1. It reads, the executive power of the Gambia is vested in the President and subject to this Constitution shall be exercised by him or her directly or through the Vice President, ministers or officers responsible to him or her. Section 72, subsection 1 of the Constitution states as well, the Vice President and ministers shall be responsible for such ministries or other business of the government as the President may assign to them. In making such assignments, the President shall have regard to the desirability of ensuring that such responsibilities are entrusted to competent persons with relevant qualifications or experience. I also draw the honorable members' attention to section 71, subsection 1 and 3, all of which point to the argument that my presence here today is by delegated authority of the President, who is or in whom the executive power of the state is vested. I take note of the concerns expressed in terms of certain sections of the Constitution which also require review, such as Section 91, subsection 1, paragraph D. I will be appearing again before this August body on the 31st of July to answer some questions that have been raised by this Honorable Assembly. But allow me to say here and today that there are plans to have a constitutional review commission, to establish a constitutional review commission that will be responsible for writing a new constitution of the Republic that will usher in the Third Republic. We have recently finalized the draft concept note and terms of reference for this, and the decision was the result of recommendations made by a broad section of participants at the National Stakeholders Conference for Justice and Human Rights. I believe some members from this Honorable Assembly attended or participated in that conference. But perhaps I will speak more on this matter when I appear before you again on the 31st to respond to the concerns on specific provisions of the Constitution. But I believe that the Constitutional Review Commission, when it is established, will take on board comments, views from the public, including honorable members of this Assembly, as they attempt to draft a new constitution. It will, of course, include consultations on, for instance, the lower age limit as well. I think it is important that we all have an open, fair, and transparent process in which everyone is given the chance to express themselves. And there is no doubt that the youths of this country have contributed immensely to this change that has allowed us to be gathered here in this manner. But perhaps I'll just add that while I have no strong positions on this issue at this point, I'd just like to take a cue from the comments by the Honorable Member for Kantor that former President Jammeh was quite very young when he took over power, and we saw the potential calamity that a lot of power concentrated in youth can do. Although, as I said, I am not one way or the other on this matter as yet. I take on board the concerns expressed by the nominated member about the piecemeal amendment. I agree with you that we should discourage a piecemeal amendment of this constitution and adopt a holistic review of it, and that is why the decision to establish a constitutional review commission to write a new constitution of the Gambia is being considered seriously. However, it is due to the exigency of the circumstances that has led us to present this bill to amend these provisions of the Constitution. Obviously, we would need a fully empaneled Supreme Court bench going forward. It would save a lot of costs. It will prevent the government from bringing in foreign judges and pay them a lot of money, where we can have our own homegrown judges who are able, equally able and competent to serve at that level, and it will give true meaning to the Gambianization of our judiciary, as we all want to say. We want to factor in unforeseen circumstances that may give rise to perhaps the issue of qualification for president. I mean, I'm not saying it will happen, but for practical purposes, should there be a need to conduct elections between now and the next 3 years, then you are going to end up, if you still have the provision, exclude a very significant section of the Gambian populace from contesting, and that would be discriminatory, as I said earlier on. So in view of these reasons, we thought that these two amendments are necessary at this point in time. And while I am not saying that the amendment to section 91(1)(d) is not necessary, I am hoping that none of the members here would be subjected to unsavory practices by their parties. I am hoping. That's my hope. That's my hope. I think, based on my experience here today, you are doing a fantastic job in ensuring that government is accountable to the people, and I can only encourage you to continue along this line. Otherwise, I have nothing further to say, unless honorable members have, or I have left out an issue that I was supposed to address. Thank you very much, Madam Speaker and honorable members. Thank you.
I keep on forgetting mine. The House will now go into the Committee of the Whole Assembly to consider the bill section by section.
Section 1, subtitle.
It is proposed that section 1 stand part of the bill. So yes,
Can I observe?
yes, of course, sure.
I think you have to tell us which procedure are we going to take, which format. Are you going section by section? Or
I did indicate that we are going section by section.
it will indicate it here.
Oh, at the committee stage.
Exactly.
Yes, very well. We are going to consider the bill section by section. The reason being that it's not a very short, it's not a very long amendment. It's only one section that is being amended. It is proposed that section 1 of the bill stands part of the bill. Those in favor, please say aye. Those not in favor, please say no. So the ayes have it.
Section 2, Amendment of the Constitution.
there appear to be some argument over whether it is section or whether it is clause. That if it is amending the bill, we use clause. We use the clause, and then we come to sections when they're dealing with the act itself.
Correct?
Then you can go ahead, Clerk.
Clause 1, subtitle.
It is proposed that clause 1 of the bill, titled "The Constitution of the Republic of the Gambia 1997 Amendment Bill 2017, form part of the bill. Those in favor, please say aye. Those not in favor, say no. So the ayes have it.
Clause 2, amendment of the Constitution.
It is proposed that clause 2 of the bill, entitled Amendment of the Constitution of the Republic of the Gambia, stand, form part of this bill. Those in favor, please say aye. Those not in favor, say no. So the ayes have it.
Clause 3, amendment of section 62 of the Constitution.
It is proposed that clause 62 of the bill, entitled Constitution of the Republic of the Gambia 1997 Amendment Bill 27, form part of this bill. Those in favor, please say aye. And those in favor, please say aye. Those not in favor, say no. So the ayes have it.
Clause 4, amendment of section 141 of the 1997 Constitution.
It is proposed that clause 141, subsection 2, amendment of section 141 of the Constitution of the Republic of the Gambia, stands and forms part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Yeah, the assembly now resumes.
Sini. Uswa ibina kamera tena.
Bill, Constitutional Amendment Bill 2017.
At this stage, call on the Honorable Minister, the Attorney General and Honorable Minister for Justice to report to the Committee of the whole House what has transpired at the committee stage.
Honorable Speaker, I report that the bill entitled An Act to Amend the Constitution of the Republic of the Gambia under Section 226 subsection 2 and for connected matters having gone through the committee of the whole House without amendment be read the third time and passed.
Thank you, Honorable. It is reported that the bill entitled the Constitution of the Republic of the Gambia 1997 Bill, Amendment Bill 2017 without amendments be read a third time and passed. Those in favor, please say aye. Aye. Those not in favor, no. So the ayes have it. Yes, may I take this opportunity to thank the Honorable Minister and Attorney General and also all honorable members for taking part in this debate and for a successful session, and that this and on that note, I will put the question: be it resolved that this August Assembly do stand adjourned till Wednesday, the 26th of July, 2017. Those in favor, please say aye. Aye. Those not in favor, please say no. So the ayes have it. The Assembly now stands adjourned till Wednesday, the 26th of July, 2017 at 10 a.m. Thank you.